All right, we're gonna get started. So 115, who has been exposed to trade secret type cases? You've heard about it, right? But, okay. And then just by a raise of hands, like how many 1Ls? 2Ls? 3Ls? Okay, awesome. All right, so today we're talking, and I'm gonna be the person dealing with the laptop remote, and I'm going to get started. So it's a pleasure to be here. Thanks to Wayne, of course, and BCLT. We also are proud here. We have 3 Berkeley Law alums. So Berkeley Law alums, raise your hands. So
awkward.
We love Leslie. We love Will anyway, but it's a real treat. Today we have both practitioners as well as clients, and we're going to talk to you about just, trade secrets. And the way that I frame it, just before we get started, is when I was in law school, I didn't really understand, like, what does a trade secrets case mean? And a lot of the cases result from the ingress and egress of employees, right? Because when they leave in competition, oftentimes they take their knowledge, their confidential information with them, and which results in trade secrets cases. So the point of this panel, there's a lot to cover, and I'm probably my panelists know that they don't have a ton of time, but just real quickly, just to introduce ourselves, and then we're gonna get into the substance. Quinn Taw, litigator. I grew up at sort of several trial boutiques, did a federal clerkship, public interest fellowship, federal clerkship, then worked at a number of firms. Private practice, I think, has been very gratifying, and I would say my pitch for it is there are firms where you can do what you want to do and still do social justice work, and I think it's given me a lot this practice has given a lot back to me. So happy to be here, and I'm in the Bay Area office of Skadden. So Ryan, can you introduce yourself quickly?
Yeah, Ryan Posey, Berkeley Law, class of 14. I've definitely had a lot of scary moments in this classroom, so it's good to be back. I am the head of the West Coast Labor and Employment Practice at Skadden. I sit down in Los Angeles, but I also sit up in Palo Alto as well. My practice is hybrid. I do transactional work, advice, counseling, and litigation with Quinn and others.
Leslie?
Yes, hi. I am not a Berkeley Law alum, sadly, as these are all saw from the show of hands. But I love coming here. I love coming to the West Coast. I flew from New York out of the polar vortex yesterday, so very, very happy to be here. I'm a partner in the IP litigation group, collaborate with Ryan, with Quinn all the time. Our practice spans all types of tech IP. We do trade secret cases, patent cases, breach of contract cases if there's technology involved and the general litigators don't want to touch it. So you have a tech litigation problem, you call us.
Exactly. Eric?
Hi, my name is Eric Alderetti. I'm a double bear. I am in-house at Molina Healthcare, where I manage all the litigation for the company. I've worked with Quinn for 15 years. I've worked with the other attorneys on this panel for the last few years. And I didn't know boo about trade secrets, and I rarely showed up to class.
And Eric works at Molina Healthcare, which is a Fortune 125 publicly traded healthcare company. So he, healthcare, semiconductor, and I would say energy are the most competitive where we see a lot of these disputes. Will Mosley?
Hey everyone, Will Mosley. I'm at Applied Materials, which is the world's largest semiconductor equipment manufacturing company in the world. I've been there for about 6.5 years. I'm a senior director in the global litigation and investigations team. Worked on some very high profile trade secrets matters, including with Quinn. We have some great stories from that one. Look forward to having this conversation.
Great, thank you. So we wanted to keep it practical, not just a bunch of law firm partners talking to you, but also from the client side, so you can see how interesting it is. Before I get started, so real quickly, the way I see trade secrets is advice and counsel, which the 3 of us do. Ryan does probably the most of it, advising on various issues, non-competes, all that stuff. And when you're an associate, you're like, this is so boring. But guess what? If you're writing the non-competes, guess who's going to enforce it? You. So it's a practice that is very important. Our clients come to us all the time. Then I would say the other tranche next is like civil litigation. So we're always trying to drag Ryan Posey into litigation. I can make anyone a litigator, but Leslie and I do litigation full time. He does quite a bit of litigation and also advice and counsel. And then I would say, third, because civil litigation involves also state court cases. So like Eric and myself, Will, we've been in state courts across the country. The third tranche I would say is like hardcore sort of IP, patent, that type of stuff. And then I would say the fourth tranche that trade secrets covers is white collar. So Will can touch on that later if he wishes, but some of these cases where there's exfiltration of information to other countries, to China, et cetera, the DOJ sometimes gets very interested. So that's why I think it's such a great area, because it covers so many different types of specialties. Okay, so real quickly, and we're gonna blaze through this. Leslie, you have very little time to explain this, but please do.
Yes, absolutely. Overview of IP. So let's talk for a second about, and I mean literally a second, because we can't do all of IP in a 45-minute segment. What I like about trade secrets is that it's different from the other types of IP. You don't have to go to the government. You don't have to deal with a process where you're telling the public what your technology is, and you're waiting and crossing your fingers and hoping that you get your certificate they can go out and enforce. A trade secret is what you claim it to be. Now, that doesn't mean you don't have any work to do as a trade secret plaintiff. You have to educate your employees, mark your documents, make sure that you're taking steps to keep your crown jewels secret. But that's what makes trade secrets unique amongst the other types of IP. Really, it has to be secret, and then to have a claim, someone has to have taken it. They either acquired it wrongly, they're using it wrongly, or they're disclosing it without your permission.
Okay, great. Next slide, and we're covering, we'll have the deck for Wayne if you all want to see it later. But just real quickly on this one, it's covered under both state and federal law. Just a refresh, there's a Unified Trade Secrets Act. It's been adopted in about 49 states and the District of Columbia, with the exception of New York. But those of us who do trade secrets cases usually can practice across the country with local counsel. And Leslie already came down on here and talked about the protectable trade secret. Just put in your brain that under California law, to declare something a trade secret under the Civil Code, there's also something called the 2019.210 requirement, which Will knows all too well, because you have to draft that. And for very technical cases, it's very important to have someone who understands the technology, works with the engineers, et cetera. And obviously, like Leslie just said, the defendant must have misappropriated the trade secrets. That's why employment mobility is such an important part of this practice, because it's usually, not always, but someone who's working at a company who goes somewhere else, and oftentimes they take something, right? And it's usually a trade secret. Okay, so best practices to protect disclosure by employees. This part is a little bit of background so that you have a sense of the trade secret practice, because we could just jump into the civil litigation, but that doesn't give you the full picture of the practice. So I wanted to talk about non-competes and turn it over to Ryan Posey, who we advise and counsel all the time about this. So Ryan?
Yeah, so I'll talk about the status of non-competes at the federal and state level briefly. I will say, I guess, how many people in here are probably doing transactional work or want to do transactional work? Okay. So for you all, non-competes are important because it's going to be on the term sheet for any M&A transaction that you do. It's one of the critical components to protecting the value of goodwill that's acquired in a deal. For antitrust folks, there's also a very large component to non-competes and other restricted covenants, because the protections for employees, consumers, et cetera, are born out of antitrust law. And then for L&E practitioners, labor and employment practitioners like myself, obviously this pertains to employees, and so we get looped in to draft these things, negotiate them, et cetera. So at the federal level, this non-competes, it's not a partisan issue. I think both sides of the aisle have tried to scale back companies' usage of non-competes. There's not going to be any legislation that's going to come out of Congress, and so what certain executive branches have done, especially under the Biden administration, was they sought to curtail the use of non-competes at the federal level through agency enforcement action and through rulemaking. So in 2024, you guys might have heard of the Federal Trade Commission's final rule that would have essentially banned all non-competes. And there was an immediate litigation on that matter. And the Northern District of Texas in 2024 set aside the rule. They said that the FTC overstepped its authority, the rule is overbroad, vague, et cetera, and essentially declared the rule invalid with nationwide effect. The FTC and the Biden administration appealed that decision. There was briefing occurring, and of course there was a change in the administration. And when the Trump administration's FTC came in, what they decided to do, they voted 3-1 to dismiss their appeal and to instead think about the curtailing of non-competes through specific enforcement action. And they've actually done some things. One of the things they did, surprisingly, was they did an enforcement action against the nation's largest pet crematory business, which is a little random. Could have been a little bit of a political hit job, nobody knows, but they have done something at least, and then they've sent notices out to healthcare companies and staffing agencies asking for additional information about the use of non-competes. Now, that was the FTC. The National Labor Relations Board, which is the agency charged with enforcing the National Labor Relations Act, also did some things during the Biden administration, issued memos saying that non-competes violate employees' right to engage in protected concerted activity. But of course, when the administration changed over and the agency's leadership changed over, they abandoned those memos and are now back to essentially doing nothing. So at the federal level, there's no nationwide non-compete law that's in effect. And so we'll transition to states next and talk about non-compete at the state level.
Exactly. So where we're at is back to where we were at. And I think, this is just, at Skadden, we definitely do a survey and our teams look at the case law all the time, every day. But these are the 3 buckets real quickly. I mean, it could also, I could get into more details, but we don't have much time, except to show you, as you can see here, California, generally prohibited. There's ways to try to deter people from leaving, which we can talk about in a little while. But just really, the main point here is if you want to be a litigator in terms of trade secrets, you should get really comfortable with both state and federal litigation. Like with most of my clients who are publicly traded companies, I'm pretty comfortable litigating in every state because I will bring in my partners if we have an office, or if we don't, we have local counsel. But we always do the analysis. It's very bespoke. Quickly turning to Eric and then Will, I mean, as you know, it's every single candidate, we look at the laws very specifically for their situation. So maybe Eric or Will can speak to that quickly, or both.
Yeah, let me just take a step back. I think one of the things that's really important is the growth of the company depends on the people around it and the leadership in those positions. And these are real fights about bringing someone on board from another state or a jurisdiction. And it's high visibility. So in my instances, the CEO will hear about it depending upon who the person is and what the position is that they're seeking to fill. So this isn't like soft litigation. This could end up being a trial on these things. You usually resolve them, but a lot of that is driven by the state law, choice of law provisions. And I don't think people appreciate how important these hires are for a company, for its growth. And so it's lots of resources, millions of dollars are spent on litigation to get the right person in and to eliminate or at least decrease the amount of friction as you bring someone on, because you can sideline somebody for a long time if their non-compete says a year, and there's ways to shorten that and all that. But it is critically important for a company's growth, and it's critically important for my company's growth.
When Eric started, and I'm going to say this, I mean, his company was a Fortune 625 or something like that, and his new CEO came in and was like, we need to get the best executives, but every single one has a non-compete, so we need to fight, we need to figure out how to do it, and now, 10 years later, they're a Fortune 125. But remember, there's going to be fights, and this is why it's critical to have these hires, because there's only so many people in the world who have that knowledge, and it's probably a person that's working for your competitor. Will?
The only thing I would add to that is, the saying, what's good for the goose is good for the gander, right? Like, you have to consider it from both ways. Not only do you want to have the flexibility to hire on this great talent, but you also want to the extent you can, not have your great talent escape to some other company. And so a lot of times there's going to be some horse trading with your competitors as one very talented employee goes over there and then one of theirs comes over here. You don't want to be too aggressive to the point where you're just constantly engaged in this back and forth war and then nobody's getting anything done.
That's right. And you also don't want to fight so hard that you create bad case law that you then can't use it. So it's always a balancing act, and we can talk, one example of that is the equity clawback, which we can talk about in a second. Next slide, state law developments and other considerations. I mean, we track different interesting rules. Maybe since we're running out of time, can you pick one, Ryan, and talk about it that you think you've seen a lot in the transactions that you've worked on?
Yeah, look, I think the general trend here is just hostility at the state level to non-competes. I'd say that most states are trying to find reasonable middle ground to figure out what is most reasonably protective of companies' interests, but also does not really impinge upon employee mobility and the right of individuals to engage in a lawful trade or profession. So what I am seeing is at the legislative level by states, you are actually seeing more states say we're not going to do total bans on non-competes like California and 3 other states. We're actually going to limit the use of non-competes to specific executives who earn above a certain salary threshold, or who have customer relationships or have access to the secret sauce, to trade secrets. And so we're starting to see a little bit more of a measured approach at the legislative level. At the court level, we're also seeing courts kind of take their axe and chopping back at non-competes by imposing things like the janitor rule, which says that non-competes cannot be drafted so broadly that they would prevent you from working as a janitor, even for a competitor, right? So we're seeing legislatures and courts try to find as much middle ground as possible.
I mean, one thing that we faced, at least with Eric, you and I, because he's in healthcare, is like certain states will not let you like ban doctors from, for instance, working for another competitor, right? And then we had one case where it was a medical director, and even though that particular state did not have a rule that said, okay, you can't, in terms of mobility, the judge was just piping mad. We were on the side of trying to recruit the doctor over to our client, right, Eric? And
Yep.
I think it was just the judge was so mad. The other thing that is really practical that I would say is if, I think courts are just going to look at it very practically. So if the executive has a severance and they have a non-compete, then that becomes the issue, right? Like, it's fair for you to sit for a year because you're going to get a $500,000 severance. And then your former employer is like, look, go ahead, go. Would you just give me back the severance, or else we're going to litigate over it, right? Because you've now competed, because they'll make the severance the issue and the consideration for not competing. So it's that, equity clawbacks, which we can talk about in a little while. But those are some interesting issues. The next slide, I'll just talk about best practices, and then I'm going to turn it over to Eric and to Will also. So as we've noted already, it's really important that when you do non-competes, like, you regularly review. So for my clients, we do it once a year approximately, and obviously if there's a change in law, we notify the client right away and make sure that the agreement is then valid. We would say non-competes, it's not one size fits all. Oftentimes we're like, our team, because Ryan's team is tracking it all, because we do, so at Skadden, we're very strong in litigation, but also in M&A. So in all these transactions for the corporate lawyers, they're constantly looking at that, because what if one company, acquires another company and there's multiple states involved? So Ryan's team, and Stephanie, who's here, she's raising her hand there, we look at all the laws. And so when we litigate, we turn to Ryan's team, we're like, what the hell is going on right now in this state relating to this issue? And so we always are looking specifically at that one candidate, what's going on, et cetera. Where there are non-competes are permitted, one thing to look for is to be as narrowly tailored as possible. So for instance, and Will and Eric and myself, we talk about this all the time, a 1-year non-compete is likely to be much more enforceable than a 2-year. If it's a 2-year, they better be like a C-suite or a very, very senior person receiving a huge severance, that it looks quote unquote fair, right? So we narrowly tailor it. We don't make it very broad, because the broader you make it, courts hate it and there'll be more hostility. The other thing to say is we don't rely solely on non-competes. And so if you look on the right-hand side, these are the various other levers. Non-solicit covenants, meaning you cannot go and recruit all your friends. I go, come on, Ryan, come with me, right? Like, you're not supposed to solicit. Now, if they call you, that's a little bit different, right? But most people you can't just recruit a whole bunch, because that's like raiding and all that stuff. So there's usually non-solicit covenants for employees. Now, those are getting more disfavored too, but it's not illegal in most states yet. Confidentiality, I think that's like the ugly stepchild, brother, sister of trade secrets. Like, anything can be confidential, right? But a lot of companies will say you can't take in confidential information, and it doesn't expire. So it's a very vague area that I've litigated, and it's hard, and I think these folks have too. There's all these other things. Garden leave provisions is very similar to like notice. Like, you can't leave you give me notice and you have to sit around for 90 days. Well, that's not very practical, right? Because now you're the enemy sitting there for 90 days. But some employers put that in there to make it harder for people to leave. And the states, when you saw earlier, like California, judges hate that, right? Compensation packages that promote retention. So that's the other thing. And Eric and Will can talk about this too. It's like, it's both the we're going to go after you and sue you, but it's also, a lot of HR teams are like, let's make them want to stay. Okay, and then the last thing, I put a little asterisk there in terms of equity clawbacks. That's getting more and more disfavored, but what that is the following, and then Eric and Will can talk about this. But equity clawbacks are for high-level executives where, over the course of X number of years, you're going to have your equity that vests. Oftentimes that's millions of dollars. And so there was a body of law that some of us were developing that was kind of along the lines of, go ahead and compete, but you just need to give us 2 years back of your equity, which is millions of dollars. Faced with that decision, many executives are so scared to litigate because it's expensive that they'll just sit out and consult or do other things. But I've seen it in healthcare, I've seen it in energy, I've seen it semiconductor. So Eric and Will, any other best practices that you wanted to add on that you think from the company side you guys focus on?
Yeah, I think one of the things that if you're bringing someone on, so the ingress of people, you got to understand that these folks are freaking out, right? Yes. Because they're seeing money go out of their pocket. They're thinking, worst case scenario, I'm not going to work for a year. My husband or my wife doesn't work, and this is a big chunk of money to me. This is generational wealth, and I'm losing it. And for me, I didn't appreciate that until I started seeing some people cry, right? Because they just couldn't put up with the adversarial nature and people from their former company speaking ill of them in papers that were filed with the court. And I think you have to understand that, because I am very sympathetic. I hear some really sad stories about loss of opportunity and how their name's being trashed. We had one person who was served with a non-compete complaint at her son's wedding. To just give it to her. And I felt horrible about it, but I said, it can get that way, especially. You should take it as a sort of a compliment that you're so talented that they would do it.
But I think, Eric, one thing that your company has done, and not all clients do it, but some do, but his CEO, for instance, for most executives that he wants, will indemnify their fees. So I'm already representing the company. We do a joint defense agreement where I represent the employee also, so they feel like, all right, because his CEO is like, look, once we make you the offer, you're part of the family. Yep. But many, many executives don't have that situation. So if they're ready to fight and they call me, I'm like, look, I can try to help you, but maybe let's think about what we can negotiate as a pound of flesh to give to your employer, your former employer. Can we give back the severance? So I know what the negotiating tools are, but Eric's right, it's very emotional. And then Will, you've seen it from the other side too. I mean, when people leave, right?
Yeah, definitely. I actually don't have anything to add on the non-compete side, but while we're talking about employment agreements, one thing to consider as a best practice for your company is whether or not you want to arbitrate or litigate these claims, right? Because I, as Quinn knows, wound up in a situation where we were arbitrating against a former employee on a very, very complex, highly technical trade secrets case, because that was what was in his employment agreement, which was drafted without considering the impact of arbitrating that kind of case versus any other case that you would have against an employee. So that best practice would be consider whether or not you want to have that carve out.
Exactly, and we ended up going to court for the preliminary injunction and the sort of TRO portion of it, but there was a fight. Where did it belong? I mean, frankly, I would prefer it to be in court, but we ended up winning that portion, and then it got arbitrated, and that we thought that was the right result. But definitely clients should think about it. Leslie, do you wanted to add something?
I did, yes. One quick IP plug. We're talking about sometimes non-competes can be set aside, sometimes non-solicitations and equity callbacks. These provisions might not be found to be enforceable. It's not done. You don't get a carte blanche to just raid your former employees' trade secrets. You still have a trade secret claim, right? You're not without any weapons in your arsenal if that's the case.
Yep, thanks for that clarification. Real quickly, just a quick story, or really fast, but sometimes, so Eric noted something, and Will knows this too, because we've looked at stuff in Arizona and other states. Choice of law and where the executive lives is highly important. So in a situation that we had with Elevance Health sued Vinod Mohan, who was coming over to Molina Healthcare. California, here's the fact pattern. California resident, but her company, Elevance, Indiana-based, okay? So they sued, like they said, we won't sue you. And she was like, great. And I helped her get out, we advised her. Then 3 weeks later, got served at her son's wedding. And I said, don't worry about it. I'm sorry this is happening to you. Of course, we played her little violin and every pleading, served on her son. Like the judge was so mad, served, during her son's wedding. But basically, they filed suit against her, trying to enforce a non-compete. She's a California resident. So within 2 days, my team filed something in CD Cal, because that's where she was, to get that deemed unenforceable. And so the Judge Barot, he issued an order that said you cannot enforce a non-compete against her because she's a California resident. So we were like, hooray, we won. Not yet. So we ended up telling the other side, you know what, this is going to be a big fight. We went back to Indiana, and they were like, well, you don't have anything enforceable at this time, so we just let her continue working. The judge then in Indiana decided to say that she had jurisdiction to continue deciding this case, okay? And we were like, okay, now we have two dueling litigations. However, I just called the other side. I said, this is gonna be expensive. If you're ready to fight with me, go ahead. But she's gonna continue working, and we're gonna take the risk because there's no damages to you, because she's not working in the same area, like Medicare, Medicaid. We flipped her and put her in another, that's another trick that we do. We put her in another area, and then they didn't want to litigate it against Skadden, so they settled. So there you go, against my teams. And then you had the flip side of it.
Yeah, so California resident sold his business to our client, but had non-competes in his employment agreement that differed from the asset purchase agreement. So there's some case law in California that says this set of covenants in the employment agreement are unenforceable because it's not tied to the sale of business. The covenants in the asset purchase agreement might be enforceable if they're narrowly tailored. So the day that the guy resigned, his new employer and him filed a lawsuit against our client in California State Court, which was the right move if they expected some litigation. So we were scrambling for a good 2 weeks. Customers start bleeding out the door, going to the competitor, and to the points that Eric and Will had made, it's very real when the CEO calls and says, I'm about to lose $25 million, Skadden, you need to figure this out. So what we did was we rushed into Michigan, which was the governing law under the employment agreement. It's where our client's principal place of business was. It's where they're incorporated. And we had to figure out how to get over the first file rule. So typically, wherever you file first, that court's going to exercise jurisdiction, and the second court's going to stay under principles of comity and whatnot. We found the right judge. Like, we looked at every single judge's decisions on first to file. We got the luck of the draw with the judge selection. We filed for a TRO in Western District of Michigan. TRO was granted the next day. Hauled the guy and his counsel into a federal court in the Western District of Michigan, and he was quite hostile to the California guy. And we kind of played up these damn Californians think that they can have a broad law that applies across the United States. Like, that's crazy under sovereignty principles and whatnot. And the judge really bought onto it. Of course, I didn't appear in court because I sit in California, but one of my partners on the East Coast appeared in court. And we ended up settling the case, right, because we got the TRO, but we're going to be dealing with the same issue that Quinn described, because the California courts were going to hold on to the case, right? And it was going to be a dueling action in Michigan and California. But we created enough of a mess to get the other side to agree to pay us back for the customers that they took and some.
Yeah, I mean, at the end of the day, a lot of these cases settle because you have a sense that it's going to be very costly. And we just come in and we're like, our CEO is going to spend millions of dollars. What do you want to do? And they usually are like, all right, let's settle. And plus, we're repeat players, right? So like in Eric and my case, but like Eric said, it was, it got exposure. The CEO was on the phone with us the whole time, et cetera. Anything else you want to say about Vinod's case, Eric, from the client perspective?
No, other than, I did not expect to have it filed in 2 jurisdictions. I think that really threw me for a loop. And I just thought, wow, this is going to be going on for a long time, and we need to get her integrated into the company.
Yep.
Luckily, I had Quinn with me who's pretty aggressive. And
oh, really?
That's what we, yeah, oh, really? And that's what we needed at that point, because this was an important hire, and she deserved to be working at the company. I don't think anybody disputed that.
Yeah, and what we do generally is to protect the company. Like if she's in Medicare, we'll put her in Medicaid. If she's in Medicaid, we put her in Medicare. We try to put them in something different, at least during the course of litigation. So if the other side's like, you stole my trade secret, we're like, we wrote a memo, it's called a walling off memo, she's not gonna touch this. We do that until the litigation is resolved. And then once we do, then it's fine, right? So that was the other thing that I think we do quite a bit. But just to show you, if you look at this chart, and I won't, you won't have time, but I can give you the slide deck. It's all over the place. When there's dueling actions, sometimes it's void, sometimes it's not. So you got to just race to the courthouse. For the California residents, I'm always going to California right away. And so I've been called by a bunch of clients, like, what do you do? And we were one of the first people who did this and got a really good result. And there was enough leverage for us to settle.
I guess we should just quickly, because there's
Yeah.
a 95% chance that one of your friends is going to ask you about a non-compete that appears in their employment agreement. And just so we're all on the same page, in California, they're generally banned.
Correct.
Unless you're the seller of a business or goodwill, or you're an LLC member or a partner in a partnership. So I guarantee you one of your friends is going to call you and say, hey, I got this agreement. Let me know if it's enforceable or not. So do your duty to the profession, and just if you have to take anything away from this presentation, in California, non-compete's generally banned unless a narrow exception applies.
And don't just give legal, you guys all
Yeah.
know this, legal advice by Googling it or going to an LLM. It's so bespoke and so specific that you have to look at all of that stuff. Eric's smiling, someone who loves LLMs, but even he does not rely on that.
That's
without talking to
ChatGPT for
counsel.
you kids, man. Not learning machines.
Okay, I'm gonna skip to civil litigation real quickly, and just tell you about the civil litigation aspect. That's a big part of our practice. What we talked about here with this was advice and counsel, but that arises to litigation. It's super important. If you want a thriving trade secrets practice or employment mobility, you have to have a clear grasp on the stuff that we talked about. Okay, so on frontline issues for plaintiffs and defendants, Leslie, you want to blaze through that real quickly?
Yeah, sure. Happy to cover civil litigation in 5 minutes. Okay, so all of civil litigation boils down to this. Very biased view as an IP litigator. If you are a company with information, spoiler alert, that's any company, you should be thinking about how you're protecting that information. So number one, you have your company crown jewels, stop the theft. Make sure you have procedures in place that make it super hard to steal the information with your employees, with vendors, with any third parties, even hackers. Number two, you're in the situation where you have information leakage, then you want to get that information back and you want to stop the damage. And that is, when you're probably calling Quinn and me and saying, where can we sue, when can we sue? But there's conversations you can have with a bad actor even before you get to a lawsuit. From a defense side, you're not always defending a super guilty party, right? I mean, you could receive a cease and desist from another company that is sent in bad faith. They don't actually think you have anything. They just don't like that you're competing now. They don't like that you have their employees. So step one as a defendant or a potential future defendant is this real? Is this the real deal? Investigate the risk. How do you do that? There's a lot of tips of the trade, but you can call vendors, you can have infiltration analyses, you can set up clean teams while you're doing this exercise so that you have your employee, especially in the tech industry, work on their own totally separate project that is different from what they had done at the previous employer.
Great. I'm going to let Will take the lead on this next slide because I think I've done a lot of work in the semiconductor industry, and I would say those crown jewels take years and years of R&D. And so in terms of plaintiff side considerations and preventing theft, Will, do you want to sort of talk about some of the things that, in your industry, companies do?
Yeah, so obviously everyone can just read the list here. I think it's a very good list. And so my value add will be very, very carefully caveating that first bullet point. I think there are certain instances where it does make sense that if you have something that you're protecting as a trade secret, to label it as such. Great example would be secret recipe for Coca-Cola, right? You should definitely label that as your trade secret. That's your trade secret. In my industry and in my company, which is semiconductor, I would not label something as a trade secret or recommend as a practice to label things as trade secret. Why not? There is so much information that we deal with. There are so many documents. There are so many design files. How do you know what is and is not a trade secret at the time of the creation of that thing? So if you start saying, well, I think this thing is very, very important, I'm going to label it as a trade secret because I want to be very careful in case somebody takes that. Maybe that's not the thing that your competitor is interested in. Maybe the competitor is interested in something that nobody thought of as being interesting because they hadn't connected the dots about how that one thing can actually enable the competitor to become competitive in a specific space that they aren't already in, which is an actual fact pattern that I dealt with. So I actually recommend in that situation being very ambiguous. Everything is the trade secret because you don't know what's going to be stolen yet. But you also have to be very, very careful that when something is clearly not really confidential information, don't over-label and then dilute the title of, oh, this is confidential information and it's a freaking like packing list for, for a power cable. Like that's not going to be helpful for you in the future.
And then, and then once you litigate as a trial lawyer, you don't just, oh my God, this is a trade secret. Like under California law, you actually have to do a list, and then it's not just throwing some patents in there. You have to be thoughtful. Like, what was this trade secret? Is it a recipe for making Coke? Or in my case that I had, another trade secrets case, semiconductor, was it the recipe for how to fabricate that has 1,000 steps for these various wafers that get cut up into chips? Or in Will's case, is it the schematics and the dimensions of these chambers that help you fabricate? And then you have to list the dimensions, right? So it's being very thoughtful, but it is very helpful in the sense of my semiconductor clients. Most of the chambers will say they're trade secrets. These recipes are trade secrets, and then we have to further define in litigation. Okay, so
Quinn, let me just
yes,
add one thing.
Eric.
Will, one of the things that Will said is that you've got to label it. And in my industry, what you also have to do is you have to take measures to make it confidential, right?
Yes.
Get limited access for people to have this document or this trade secret, because if everybody has access to it, then it's probably not going to be a trade secret. And in my world, we limit what people can have access to through passwords, different websites, or different share files. So that's one way we keep what we have confidential.
And in Eric's world, the thing that's the crown jewel is how to win these major RFPs, like to get a contract with the state. It's multi-billion dollars and years long, and how to get that contract is like, this is what we do, this is what the healthcare, and it may seem vague, but it's not, because every state is a state-by-state analysis of how to win these contracts. So his trade secrets in the healthcare world is often, it's captured within the RFPs for a certain period of time, and then 1 or 2 years later, it might be something different.
Yeah.
But that
Also,
would probably be the trade secret.
To very carefully caveat that first bullet point further. Just because you label something trade secret does not
Yes.
mean that it'll be entitled to trade secret protection.
Correct.
Right? Like you may think something is very, very special and important. A lot of times it won't be.
And then the
Right.
next one, and we still have 10 minutes, so I think it's important for just like plaintiff side considerations, identifying theft, and we had a case together, so Will, why don't you do the honors, where this person sent trade secrets to himself, to his Yahoo from Applied Materials email, and I'll turn it over to you.
Yeah, so this was a very interesting and frustrating case that we ultimately won. I was very happy to work with Quinn on this one. But there was a very senior level employee who decided to get very clever. He was going over to a competitor where several of his former colleagues were now at. There's a whole dynamic there that I don't have the time to get into, but bottom line is he wanted to be the latest in the series to go over to this competitor. And there was a suspicion that we had that every single person that was going was attempting to bring information with them that was going to enable this competitor to enter into a new space, which was one of their stated objectives in terms of the various tools that are involved in the life cycle of semiconductor fabrication. So this was a very critical engineer, and he started sending himself a variety of files under seemingly innocuous file names, like his 2021 taxes, and it just so happens to be a CAD drawing, or phone numbers for my wife, and it happens to be mathematical equations describing the certain physical properties of something that he was working on. He was also sending himself presentations that described certain components that he had no business working on, but which would have been helpful within his new scope of work at his competitor. So we were able to catch this through our own internal kind of forensics work. We have a team that's dedicated to this odd network activity, and it was flagged, and then reached out to Quinn and very quickly had to seek a temporary restraining order against this individual and the competitor, because there was a very narrow window of time to basically stop that train in the station and make sure that there was no further use or disclosure or dissemination of those trade secrets. Because this competitor had a parent company that was in China. The moment it goes overseas, you're done. It's
Yep.
gone, right? You have no recourse once your crown jewels are literally out the door.
Yep.
And so that was a wild and exciting ride.
Go ahead, Leslie.
One of my other favorite super smart thief stories is a former employee leaving. The company does their typical checks. They get their computer back, they check their phone, make sure there's no red flags. His last Google search: how to wipe computers.
Yeah.
Oh my God.
That one, yes, it was not a forensically sound situation.
Yeah, so just real quickly, because then I'll close it up on the defense side stuff and what's coming, because we're at 1:53 and we have 7 minutes left, so we'll be finishing exactly on time, is injunctive relief. So what in Will's case, in that case, we had to go into court, get something, get it enforced, tell them they can't do this, because what if they take it to China and then we're over? In Eric's case, we usually go in for a TRO to stop the person from beginning work. And so a lot of times we can prevent that just by being very practical, and Eric will go call the in-house counsel on the other side, and then if it gets really contentious, outside counsel with in-house counsel, we talk it through, and usually we can resolve. And if we can't, then we go to litigation. But it's really important that the person doesn't start work, and then in this case, if they've started work, which they have in Will's case, we need an order to say you cannot use these trade secrets, don't do anything, don't delete anything, give it back to us.
Yeah, I do want to flag the happy ending in this case. The competitor company threw that employee under the bus. He got hit many, many times. His life is in absolute disarray.
Yep.
Thanks,
true.
Quinn.
But it did take 11 days of court hearings for the TRO, preliminary injunction, and a 1-week, essentially, trial and arbitration, and we prevailed. So happy about that. Okay, do you want to close up on the defendant side considerations real quick? I'm on slide 24.
Sure, absolutely. So I think we touched on it earlier. As a potential future defendant, what's the first question you ask? Is it real? And do your diligence. You don't just hold one meeting with an employee that you're trying to bring on and they say, no, we're good. I don't have anything. What are they talking about? It's garbage. You have to, it's trust but verify, right? You need to look at their files. You need to, I would even in some cases
Yep.
talk to their future teams. So you need to do your own diligence to assess the risk. And one last point is that may cause you to take a step back and think, what are my practices more broadly? Do I need to have an extra step when I'm bringing people on of sitting down with them, understanding what they were exposed to, understanding how their job will compare to their past job?
Yep. And so for both Eric and Will, there have been situations when they're like, hey, we want to bring in this hire in. Can you talk to them? And I've had situations, not with these clients, where I end up talking to the employee and they're like, I took all this stuff, Quinn. Here is my hard drive. And I'm like, oh God. Okay. Then usually I tell them, you need to hire your own lawyer. I represent the company, not you. So that's the first thing I do, just in case we need to separate ourselves, right? In this case, we were able to work something out. We returned everything. We had declarations signed, but it's very, very difficult, right? And then when there is litigation, real quickly, we always challenge the sufficiency of the pleading potentially. We usually, part of the sufficiency of the pleading, let's say your client gets sued, after we've done our due diligence, we also look to see if the trade secret is actually a trade secret, right? And then we look to see if the company that's suing us, did they take reasonable measures to protect trade secrets? Did they do that? Did they label it? Otherwise it's really fake, it's not a trade secret. Challenges to sufficiency, yes, this is what I was talking about. The 2019 list, many federal courts also have a similar requirement, right? Jurisdiction venue, we do that all the time. I gave you some examples. Statute of limitations, are these trade secrets stale? And then just to close up, there's a few things. Extraterritorial, one, you have 20 seconds, anything
20
about?
seconds, yes.
Extraterritorial.
Okay, sure. In America, let's just talk about the founding of America. I'm just kidding. There's a presumption, though, that U.S. laws apply in the U.S. Fair enough, right? Not all statutes work that way. The DTSA is one example where it will cover conduct that occurs abroad as long as there's an act in furtherance of misappropriation in the U.S. And so what does that mean? Exactly. What that means is you can tag a lot more conduct in U.S. courts. Your damages awards can take into account foreign sales. As a trade secret plaintiff, you can have a lot of fun.
Yep. Equity clawbacks, real quick?
Yeah, so new doctrine emerging. Eric kind of talked about it from the practical standpoint. Employees who go to another company and violate a non-compete, and the forfeiture provision is you lose $2 million worth of equity, huge deterrent effect. Some courts, Delaware and New York, are saying, well, those aren't really non-competes. An employee has a choice about whether to forego the economic benefits arising under the agreement with the non-compete and going to join a competitor, or not competing and keeping the rights to the benefits. Some courts are saying, yeah, that's fine, employee choice. Other courts, like California, kind of mixed right now, leaning towards non-enforceable, but that's a new doctrine that's emerging.
And I would say the executives generally are so scared unless there's a company that's willing to indemnify them. And if the executive's high level enough, sometimes they'll even indemnify the clawback in the event that that's at issue. And then the last bullet, I'll just close up by saying AI. We're handling a few major ones, our firm, on generative AI, meaning, is that even a trade secret? You know, like everyone is dumping information into these large language models. And so all of these questions are emerging. So it's a very interesting area of law. I'm going to close up on that. I'm going to thank my panelists, thank BCLT, Wayne Stacy, and hopefully you guys will join us in this practice of law.
Thank you.